H.R. 6131, the Veterans Disability Claims Notification Improvement Act, and the Honoring Our Promise Act discussion draft. First, regarding H.R. 6131, I and others on this committee were concerned about and followed closely the impact of the VA mailing delay caused for veterans in the claims process, especially during COVID, and work with the VA to ensure the impact of these delays were mitigated as much as possible. Still, outgoing VA letters have been arriving up to 60 days after the date of the notice to our veterans. To address this issue, I, along with Subcommittee Ranking Member Nels, thank you for working with me on this, have introduced the Veterans Disability Claim Notification Improvement Act. It represents a small but very important step to help bring the VA claims processing into the 21st century. Under this new legislation, any veteran who wishes to any veteran who wishes to continue to receive paper notifications can and will still continue to do so. But for veterans who prefer to receive electronic notification, this would actually allow them to opt in to receive their notifications about their claim electronically, thus speeding up the process and allowing them to receive the information as rapidly and efficiently as possible. Additionally, the Veterans Disability Claims Notification Improvement Act could also have a positive impact in reducing the backlog of claims at the VBA, as there'll be less delay due to the speed of mail going in both directions. And to a small extent, this bill could also result in some potential cost savings for the VA. So I hope my colleagues will join me, as well as Ranking Member Nels, in viewing this legislation favorably. Regarding my second bill, early this winter, our committee launched a survey to hear about the experience of veteran survivors. We heard from over 200 survivors across the nation about the challenges they face when accessing benefits at the Department of Veterans Affairs. So we greatly appreciate those survivors taking the time to share that information with the committee. And we learned from that their top issues mirrored the findings of the VA Veterans Experience Office, which included that outreach plays a key role in veterans and survivors learning about benefits. So what that means is essentially a lot of times these families, these survivors, they don't know about the benefits because they haven't had that outreach. And the process of applying for benefits can be challenging. I think all of us have heard that as well through our congressional offices and from our constituents. And survivors often don't know what benefits may be available to them. And that veterans who prepare for their passing set survivors up for a smoother process in applying for VA benefits. So those veterans who've planned ahead and have collected some of this information and provided that to their survivors in advance of their passing, have made it a much smoother process for family members. Those findings were reinforced at our hearing that the subcommittee held in late February, where we heard survivors feel like second-class citizens when accessing benefits at the VA. And witnesses shared experiences about survivors who didn't learn for years about the benefits that they might be eligible for, or even worse, found the process of applying so confusing that they just gave up. Leaving these benefits unused and families struggling both emotionally and financially after the loss of their veterans. So my bill, the Honoring Our Promise Act, would work to address this issue in a number of ways. First, the bill requires the VA to work with the appropriate advisory committees as well as VSO stakeholders, and thank you to our VSOs who've joined us today, to develop democratic data collection to help identify those underserved populations among our survivors, the ones who are hardest to reach. Then once identified, it requires the VBA to begin including more robust demographic data in their annual reports. And the VA then must create robust outreach and education strategies for these populations. So we know that our VSOs are key partners in this outreach effort. And so this bill also includes small grants to assist VSOs in efforts to reach more survivors in our communities. Secondly, this bill will require the VA to work with various federal agencies, including the Social Security Administration, the Centers for Disease Control and Prevention, to develop a process for distributing information to VA survivor benefits to provide that support upon notification of death. And something that was interesting for me through this process is what exactly is the process for the VA to learn that a survivor and a veteran has been deceased? And so I think that other federal agencies, the Social Security Administration, CDC, and others who receive that information in the course of their normal work, there's a lot of opportunities here to improve that coordination with the VA to help get the information to our survivors and get them the benefits more quickly. And so as Chairman Stacano stated earlier, these agencies shouldn't work in a vacuum. They should be working together to cross-share this information as well as information on other federal programs when possible and where appropriate. So I think this is one of those times where cooperation will help our veterans and our veterans' surviving families. To ensure easier access for survivors who use VA websites or call centers, the Honoring Our Promise Act requires the VA to review websites and standardize materials to ensure that they're both clear and inclusive. And additionally, this bill requires the NCA, the National Cemetery Administration, to carry out and report on their pre-need eligibility determination program. And finally, my bill requires the VA to assess the Office of Survivor Assistance to ensure it has adequate resources to serve this population. Through the hearing, I was shocked to learn that this office only has 2 employees to serve a population of approximately 450,000 survivors. I look forward to hearing the views of the VA and witnesses on the impact of these 2 bills and what they would have in modernizing the notification process, as well as ensuring survivors are provided the support they need to access the benefits earned by their veteran. And now I will shift to Ranking Member Nels, who I will also recognize for 6 minutes to deliver remarks in support of your bill, H.R. 6064, and your draft bill, the Modernizing Department of Veterans Affairs Disability Benefit Questionnaires Act, which was recently introduced as H.R. 7188.
Thank you again, Chair Luria, and I truly do appreciate your support of my bill, H.R. 6064, which we introduced together following the Joint DAMA and Health Subcommittee hearing on VA services for military sexual trauma survivors. During the hearing, we heard that applying for disability benefits due to MST can often be stressful and re-traumatizing for veterans. I believe improvements are needed to ensure that these veterans feel comfortable filing a claim, including when they receive a disability exam. That is why my bill would require VA to partner with the National Academies of Sciences, Engineering, and Medicine to review these exams. This study would help ensure that exams are conducted in a sensitive manner and identify alternatives if the veteran does not wish to undergo an exam due to experiencing MST. No veteran should leave an exam feeling distressed, and we must find better ways for examiners to conduct them. I've also heard concerns that Dbqs are inadequate for diagnosing conditions linked to MST. Therefore, the National Academies would also determine whether VA's rating schedule and Dbqs are up to date for MST-related disabilities. H.R. 6064 would also examine the credentialing and training requirements for disability examiners to ensure that they have the right qualifications. It is unacceptable that MST survivors don't trust VA's claims process. I believe the National Academies have the expertise to provide answers to these questions and solutions where VA is falling short of these veterans' needs. Additionally, as I mentioned in my opening statement, I'm glad H.R. 7188 is on today's agenda. This bill is intended to make the use of automation to process claims more effective and accurate. H.R. 7188 would also require VA to provide a plan for a convenient online portal that a veteran's private physician can use to submit a Dbq that is compatible with automation. This portal is intended to provide veterans with a more effective option to submit medical evidence in support of their claim. I believe such a portal could reduce the need for a veteran to report a VHA or contract disability exams. This is crucial when many veterans have the difficulty attending their exam due to juggling full-time careers while caring for their family members. And I look forward to discussing with witnesses suggestions for how my bills can be improved. And thank you, Chair Luria, and with that, I yield back.
Thank you, Ranking Member Nels. I will now recognize Representative Rosendale for 3 minutes to deliver your statement in support of the discussion draft of the Expediting Temporary Ratings for Veterans Act. So, Mr. Rosendale, you're recognized for 3 minutes.
Thank you, Madam Chair, and Ranking Member Nels for holding this hearing dedicated to fully utilizing technology to support our veterans. The Expediting Temporary Ratings for Veterans Act would directly help some of the sickest veterans who depend most on the VA disability compensation benefits. When a veteran's hospitalized for at least 21 days of service-connected condition or illness, current law grants them a temporary increase in their disability rating to 100%. The problem is those rating increases may not be granted before the veteran leaves the hospital, or granted in the right amount, or granted at all. The Office of Inspector General has documented widespread errors in a 2020 report. In their audit sample, 42% of eligible veterans had their benefits adjusted incorrectly or their claims improperly processed. When the VA makes a mistake and overpays the veteran, that overpayment is sometimes collected as a debt. That's unacceptable. The VA should not be hassling ailing veterans for its own error, especially at a time when veterans are in most need. The good news is we have everything that we need to solve this problem. The VA already has all the medical records information it needs to determine who is hospitalized. That's in the existing EHR VISTA system. The VA has been conducting a limited pilot program to automate these total disability claims for certain veterans that have cancer. My legislation would expand this successful pilot in 1 year to speed up claims processing for veterans hospitalized with all illnesses or conditions. Of all the VA benefits claim processes, I think this is the one that is the best candidate for technology and automation. Speed is critical, and the existing manual process tends to lag. It's also relatively simple eligibility criteria that a computer is capable of handling. I want to point out what it is not. This is not the machines taking over. VA employees will continue to make every eligibility determination. They will always decide whether to accept or reject what the automation software proposes. It's also not automation of every claim. There will still be situations where the available medical evidence is not sufficient or that information is not compatible. Employees will process those claims manually. I think this is an idea whose time has come. We can use IT to make veterans' benefits more timely, more accurate, and more consistent. I look forward to hearing the input from the Veterans Administration so that we can earn your support on this legislation. Thank you, Madam Chair, and I would yield back.
Well, thank you, Representative Rosendale, and thank you for focusing on how technology can help get benefits to our veterans more quickly. I will now recognize Representative Aguilar for 3 minutes to deliver a statement in support of his bill, H.R. 5916, the Wounded Warrior Access Act. You're recognized for 3 minutes.
Thank you so much, Chair Luria and Ranking Member Nils and members of the subcommittee for holding this hearing to discuss VA modernization. I appreciate the opportunity to testify on behalf of my legislation, H.R. 5916, the Wounded Warrior Access Act. When veterans submit claims for benefits to the Department of Veterans Affairs, a claims file, commonly called a C file, is created. And as this subcommittee knows well, you can file a C file, and it contains veterans' service records, results of their VA exams, additional information submitted by the veteran, or anything that the VA deems important and necessary to decide a claim. A veteran may want to view their C file to guarantee their benefits are being properly allocated, or to have this file for future appeals process. For a veteran to view their C file, though, they have the following 3 options. First, they can make an appointment with their VA regional facility, regional office, and physically travel to view their C file in process. Second option is they can submit a VA Form 3288 entitled Request for and Consent to Release of Information from Individual Records to seek a copy of their claims file. This process can take several months, and their C file is only provided in a paper form or on CD. Finally, a veteran can submit the Freedom of Information Act request for their C file. Ultimately, the current claims process is outdated, inconvenient, and creates unnecessary administrative barriers for veterans to simply receive timely and important information. And it's essential that VA modernize and transition from an antiquated claims filing process to new electronic claims so they can better support veterans in our districts who are in need. The Wounded Warrior Access Act would streamline and modernize the claims file process because it requires the VA to allow veterans to request their C-file through the VA's e-benefit portal that they're already likely using. If enacted, my legislation would also decrease the VA's processing time, reduce paperwork, and make life easier for veterans who want to claim for benefits. My legislation has been endorsed by 2 veterans service organizations, the Wounded Warrior Project and the Disabled American Veterans. Chair Luria, along with my testimony this afternoon, I'll be entering into the record. I'd like to enter into the record 2 letters of endorsement from these organizations and ask unanimous consent to enter these letters into the record. Again, thank you so much, Chair Luria and Ranking Member Nels and members of the subcommittee for considering H.R. 5916, and I look forward to working with you on this important issue. Yield back.
Well, thank you, Representative Aguilar. Your bill would add a fresh tool in the toolbox for veterans when they have to navigate the complexities of the claim process. And while, as the committee, we have some concerns about this tool being accessed by unaccredited individuals, we will definitely continue to work with you to try to find a way to move this type of legislation forward to help our veterans access their claims and information.
Thank you so much. Appreciate the time.
And now I will shift to Representative Neguse, who's joining us virtually, and recognize you for 3 minutes to deliver a statement in support of H.R. 6165, the Department of Veterans Affairs Post-Traumatic Stress Disorder Processing Claims Improvement Act of 2021. So, Mr. Neguse, you're recognized for 3 minutes.
Well, thank you, Madam Chairwoman, and thank you to the ranking member. I'm honored to be able to come and speak with you all today about H.R. 6165. As you said, Madam Chairwoman, the Department of VA Post-Traumatic Stress Disorder Processing Claims Improvement Act of 2021, legislation that would improve the VA's PTSD claims processing training to ensure that veterans have access to care and compensation. Additionally, I want to thank Senator Klobuchar and Senator Rounds for their leadership on this bipartisan legislation in the United States Senate. As you all know, PTSD is one of the most prevalent disorders afflicting returning veterans. Our country provides a range of benefits for veterans who developed PTSD during or after their military service. Any veteran diagnosed with PTSD symptoms can apply for these benefits, and a veteran service representative reviews the information submitted by a veteran to determine if the VA needs any additional evidence to adjudicate the claim. A December 2020 report from the Office of the Inspector General estimated that more than 15% of PTSD disability claims were inaccurately processed. The quality of life of our veterans is seriously impacted when these claims are improperly processed. And that error rate, I know, is unacceptable to everyone on this committee, certainly to me and to my constituents. We have to update and improve the national training program for VA claims and for the processors of those VA claims so that our veterans receive quality, uniform care, and costly processing errors are ultimately eliminated. Our veterans have sacrificed much for our country, and we need to repay the service that they have provided by providing quality benefits that meet their unique needs. The VA estimates that about 15 out of every 100 Iraq and Afghanistan veterans have been diagnosed with potential symptoms of PTSD. Forcing these veterans to fight again and again for the treatment and the benefits that they have earned is cruel and unnecessary. And the best way to make sure that veterans receive the care and the benefits that they have earned is to make sure that their PTSD claims are processed accurately and efficiently. It's the VA's responsibility to assess the reorganization of procedural guidance to ensure that claims processors make both accurate decisions and follow the required policies. In addition to improving the national training program, this legislation would annually update the VA's guidance to provide claims processors with better resources by analyzing the current error trends. Congress has to pass this bipartisan, bicameral legislation, in my view, to improve the training of the VA personnel responsible for processing disability claims to ensure benefits are being correctly determined. I want to say thank you again to the chairwoman for her leadership and for giving us this opportunity to present today about this incredibly important piece of legislation, and would certainly urge my colleagues to support H.R. 6165 and to help us get this done. And with that, Madam Chair, I yield back.
Well, thank you, Mr. Neguse, for this important legislation. And as a note, nearly 13% of veterans are living with PTSD. So it really is essential that the VA is doing everything they can to ensure that veterans are given fair ratings and that they take the impact of this disorder into account and consideration in disability claims. So thank you for your work on this very important issue that affects so many of our veterans. Now I'd like to recognize, it seems like a tongue twister today. I'd like to recognize Representative Newman for 3 minutes to speak on your discussion draft bill, which has now been introduced as H.R. 6849, the Supporting All Veterans Families Act. You're recognized for 3 minutes.
Thank you, Chairwoman Luria, and thank you, Ranking Member Niels, and all the members of the subcommittee for including H.R. 6849, the Supporting All Veteran Families Act, in today's legislative hearing. I really appreciate the opportunity today. This is a very important bill. I also want to thank my friend Congressman Neguse for his work on mental health, another important area. But today, I come to you in strong support of H.R. 6849. This important legislation would update VA statute to be more inclusive of same-sex veteran spouses and surviving spouses. It would also remove the outdated hold yourself out to be married language that unfairly implies shame and judgment upon surviving spouses. When the 2015 Obergefell versus Hodges Supreme Court case fully legalized same-sex marriages across the nation, the VA recognized all same-sex marriages, regardless of a veteran's status of or state of residence. This ensured all eligible same-sex veteran spouses were able to receive spousal benefits such as pensions, VA home loans, medical coverage, and more. However, after more than a decade, Congress has yet to pass legislation to formally update VA statute to reflect this ruling and recognize same-sex veteran spouses by law. Currently, VA statute defines a veteran spouse as a person of the opposite sex who is a wife or a husband. Though the VA does not enforce this outdated definition, it is long past time we update this language so that we fully recognize all veteran spouses and ensure their access to benefits are forever protected. And that is why I have introduced the Supporting All Veteran Families Act, along with Representatives Kaikahele of Hawaii and Mandera Jones of New York, to update the definition of a veteran spouse and ensure that all our service members, veterans, and their families receive equal access to their hard-earned VA benefits. As public leaders in our nation, each of us has a moral obligation to ensure that all veterans and their families receive what they need. Again, thank you, Chairman Luria and Ranking Member Niels, for your unwavering commitment to our nation's veterans and their families, and hearing this legislation to address their long overdue issue. I urge all members of the subcommittee to support this important legislation. Thank you for your time, and I yield back.
Well, thank you, Ms. Newman, and thank you for introducing legislation that both codifies the provision of benefits for same-sex married couples and removes antiquated language from Title 38 USC. So thank you for joining the committee today to discuss that legislation. And now, last but not least, I'd like to recognize Representative Mervan for 3 minutes to speak on behalf of his draft bill, the Survivor Solid Start Act. So, Mr. Mervan, you're recognized for 3 minutes.
Thank you, Chairwoman Luria and Ranking Member Niels. I am pleased that you have invited me to discuss my draft bill, the Survivor Solid Start Act. This committee held a hearing in February that discussed the lack of targeted outreach and education for survivors. Shockingly, the Office for Survivors Assistance, an office established to serve as a resource regarding all benefits and services furnished by the Department to survivors and dependents of deceased veterans, has only 2 employees. These 2 employees are responsible for a population of almost 450,000 survivors. It seems to me, at a time when family members are grieving the loss of a loved one, that putting the onus of survivors on survivors to determine what benefits they are eligible for is not in the spirit of VA's mission to serve veterans, and in this case, their surviving eligibility dependents. My bill will authorize the expansion of the Office for Survivors Assistance and require VA to reach out quarterly to surviving eligible dependents until the eligible dependent files a claim. We can and must do better for the families and caregivers of veterans in their time of need. This bill is a good start to getting them the information and support that they need, and I will continue to work with Chair Luria and the committee to find other opportunities to expand this support. Thank you again, Chair Luria, for including this bill in your hearing, and I hope that my colleagues will support this as we work to make this a law. I appreciate the time, and I yield back.
Well, thank you, Mr. Mervan, and thank you for taking that important information that we learned at the hearing in February and introducing this bill, because I think one of the most key things we've learned from listening to our survivors is that, you know, sometimes the process is complex and difficult, and they don't even know about what benefits they're entitled to. So your bill really makes leaps and bounds in the process of making sure that we can reach those families, make sure they understand their benefits, and help them through the process of applying for and receiving benefits. So really do appreciate your leadership on this issue. And that was our last bill to be discussed today. But before I move on, do any of the members on the subcommittee have any comments they would like to make on any of the bills on the agenda today? Mr. Elsie, I know, has joined us, and if you have any comments that you'd like to make, please raise your hand. If not, we will move on to our next panel. Okay. Hearing no comments from members on the first panel, I will give the second panel just a couple minutes to get seated, and then we will move on. But as you get seated, I'll go ahead and continue with the introductions. So our second panel will be joining us from the Department of Veterans Affairs. Testifying virtually before us this afternoon is Ms. Breanne Ogilvie, Assistant Deputy Undersecretary for Policy and Oversight from the Veterans Benefits Administration. And she is accompanied by Mr. Ray Tellez, Executive Director, Office of Business Integration from the Veterans Benefits Administration. So I actually think both will be joining us virtually, and I see you both on the screen. So thank you and welcome to you both. I'll remind our witnesses joining us virtually to just pause for 2 to 3 seconds before you begin speaking so you do not get cut off and we can hear all of your remarks. Your written statement will be included in full in the hearing record without objection. And Ms. Ogilvie, I'll start by recognizing you for 5 minutes for the VA's remarks on the bills before us.
Good afternoon, Chair Luria, Ranking Member Nels, and members of the subcommittee. We appreciate the opportunity to appear before you to discuss pending legislation. Accompanying me today is Mr. Ray Tellez, Executive Director, Office of Business Integration for Veterans Benefits Administration's Automated Benefits Delivery. VA offers support for several items of the proposed legislation before us today. VA is focused on providing exemplary benefits and services for veterans, service members, and their families, and is committed to modernization. To this end, VBA recently created a new office to champion the evolution of VBA business processes and technology capabilities to enable automation. The Office of Automated Benefits Delivery launched a new claims processing automation initiative in December 2021. And early prototypes have already greatly reduced veteran wait time for claims for increase by over 68 days. Ensuring the efficient and accurate delivery of benefits is one of VA's key focuses. To improve benefits delivery, VBA has undertaken several projects that are designed to provide enhanced claim processing through the use of automation. For example, in April 2021, VA completed its initial delivery of claims automation, which provided the ability to process DIC and burial claims end-to-end. This advancement in technology allows VBA to deliver timely decisions to survivors while allowing field personnel to focus on more complex claims. While VA's views on all bills are detailed in my written testimony to include areas of concern and support, I would like to highlight a few areas related to the proposed legislation, which would have profound effects on modernizing our delivery of service. First, VA supports the VA Principles of Benefits Automation Act. The modernization of VBA's information technology systems will enable VBA to deliver solutions that provide timely, accurate, and consistent benefit determinations for veterans. Additionally, the automation methodology described in the bill would ensure adjudicative discretion and adjudicator involvement in claims decisions by utilizing automation as a decision support capability rather than an end-to-end automation tool. We look forward to working with you to accelerate the development and implementation of automation capabilities through the modernization of VBA's information technology systems. I also want to take a moment to address HR 6165, Department of Veterans Affairs Post-Traumatic Stress Disorder Processing Claims Improvement Act of 2021. VA has no objection to this bill and aligns with Congress in reinforcing the importance of quality in PTSD claims. VBA has modernized and improved in this area, implementing a comprehensive training curriculum that is part of the training requirement for claims processors. The VBA training curriculum contains 8 different training modules pertaining to PTSD. In addition to training, VBA has taken increased measures by providing targeted quality reviews for claims for PTSD. Therefore, the requirements in this bill may not be necessary. Lastly, VA would like to work closely with Congress related to HR 6131, which will provide the general authority for electronic notification and support our common goal to modernize benefits delivery. We recognize that the way veterans and beneficiaries prefer to engage with VA is changing, and VA has already initiated an effort that will enable us to provide electronic notifications along with this necessary legislative support. We would appreciate the opportunity to work with the committee on minor technical changes to ensure we are maximizing service delivery to our veterans. VA shares the subcommittee's goals of providing outstanding service to veterans and beneficiaries. VA continues to work to achieve these goals through modernization and improved service delivery to veterans. We are grateful for the resources provided to us and thank you for the opportunity to appear before you today to discuss this important legislation. Chair Luria, this concludes my testimony. My colleague and I are prepared to respond to any questions that you or other members of the subcommittee may have.
Well, thank you, Ms. Ogilvie, and thank you for joining us today and providing feedback on this legislation. And of course, in the areas that you've highlighted, we would love to continue those conversations in order to improve the legislation to make sure that we can have the best outcome for our veterans. We will now shift to questions. I will start by recognizing myself for 5 minutes for questions. And the first thing I'd like to ask about, Ms. Ogilvie, is the Honoring Our Promise Act. The goal in this was to collect data necessary to identify underserved populations of veterans, really their survivors, and develop outreach and education campaigns to better reach them. Can you describe at all, some things that maybe are already in place that VBA is doing to better identify survivors who are eligible for benefits? Anything that's currently ongoing, and perhaps how this legislation could help enhance these efforts?
Yes, thank you for that question. So in fiscal year 2021, VBA participated in over 6,771 outreach events, and that reached over 274,000 veteran service members, survivors, dependents, and eligible beneficiaries to provide that information, those benefits and services. We're also partnering with a lot of VSO partners to work together to have outreach campaigns. In 2021, we also hosted a series of national outreach campaigns with State Department of Veterans Affairs and the National Association of State Directors of Veterans Affairs. We also have quarterly meetings and outreach with the county service officers to ensure that we are reaching survivors and veterans who are represented by county representation. One more thing I'd like to mention is that as part of the notices of death process for veterans, VA sends a letter to solicit claims for applicable benefits to the next of kin. This letter contains a link to a fact sheet for each applicable benefit, how to apply, and the appropriate applications to complete and submit to VA.
Well, thank you, and it does sound like there are mechanisms in place to reach the survivors. Just having the information that we gleaned from the recent committee hearing and even conversations I had as recently as this weekend with survivors within my community. Oftentimes they just feel this process is daunting. Perhaps after their loss, they're not ready immediately to apply for those benefits, or perhaps they don't have the necessary documentation to pursue them. So just look forward to continuing to work together and fill any of those gaps and really try to be able to reach the largest number of those survivors possible so that we can make sure that they receive the benefits based off their veterans service. The next thing I'd like to ask is about the Veterans Disability Claims Notification Improvement Act. You did mention that you have some efforts already ongoing at the VA to improve the delivery of notifications. Just would love to make sure that we can follow up on that, and could you provide at least maybe a little bit of feedback that you've heard from veterans or some of the challenges that have been presented by the delays in receiving these benefits notifications, to really kind of highlight why our working together and improving this process is so important?
Thank you for your question. Yes, VA very strongly supports this bill, and we appreciate your efforts to allow VA to provide electronic notification. So currently, communication through electronic means does not satisfy the legal requirements in Section 5104, which requires that VA has to send certain notices through the U.S. Postal Service. So this will give us the flexibility to be able to meet veterans' needs to provide quicker notification of important documents. And as you mentioned, yes, over the last year, there were some delays with written notifications to veterans. While VA implemented a lot of flexibilities for veterans to ensure that they were not negatively impacted by those delays, it still, I know, was a frustrating process for veterans, and it caused additional confusion. This bill would allow us the flexibility to be able to, and if that ever happened again, which hopefully it does not, but even in the fact that it may not ever happen again, it gives us that flexibility to be able to communicate in a modern way with veterans and their representatives.
Great. Well, thank you for that feedback, and I definitely look forward to our continuing dialogue to work together to speed up that delivery of information to our veterans. I would now like to recognize Representative Nell for 5 minutes for questions.
Thank you. Ms. Ogilvie, my staff consulted with the National Academies on the language for H.R. 6064. The National Academies believed they had the ability and expertise to conduct this study, especially since it is similar to the report the National Academies completed on traumatic brain injury claims in 2019. Is VA's testimony trying to tell me that a panel of medical experts does not have the knowledge needed to identify improvements to the way VA diagnoses MST-related conditions?
Thank you for that question. So VA exams require that the examiner, regardless of clinical specialty, is VA trained and certified in the VA compensation and pension disability exam process. So VBA has concerns with any independent reviewer of VA disability exams by clinicians who are not trained and certified to fully understand the intricacies of these examinations. There's a difference between medical treatment and in examinations for disability purposes. So VA has some concerns with how the National Academy of Sciences, while I'm sure they are very capable of making medical determinations, we're concerned about how they would make a determination of the adequacy of the tools and protocols used when we're talking about what's needed for ratings for disability claims.
Fair enough, but during the DAMA and Health Subcommittee hearing on MST, we heard from survivors that VA is falling short of their needs. While I appreciate VA's work to improve services for them, I believe the VA needs to think outside the box, and a review by the National Academies would enhance VA's efforts to better support MST survivors, and I urge the VA to recognize this. And Mr. Talese, VBA seems to have at least 5 benefit claims automation initiatives underway, and they are operating independently. Is there a comprehensive plan for benefits automation? And if not, tell me why.
Thank you, Ranking Member Niels, for that question. Yes, automated benefits delivery is tracking the automation efforts for claims automation. And we are working on a official schedule for that, sir.
All right, Ms. Ogilvie, I'm going to leave you with this last question here. Please describe VA's partnership with DHS to implement the Immigrant, Military Members, and Veterans Initiative.
Thank you for that question. For the immigration bills that are before us today, I will have to take back for the record to determine if we have a partnership with DHS and the extent of that partnership. But while this bill would reform immigration protocols regarding non-citizen veterans, I would like to note that under existing laws and regulations, VA provides the same veterans benefits to such veterans as similarly situated U.S. citizen veterans.
All right, well then, please describe the executive leadership triad for MST you mentioned in your testimony.
Yes, sir. So the triad for MST is made up of 3 executives in the field operations office, in outreach, and compensation service, which are the areas that deal with MST most frequently. These 3 work together on the playbook that we're working on for MST that was recently finalized. They work together to make decisions in the MST realm to ensure that the MST claims and decision processing is meeting the intent of the IG recommendations, as well as the letter that Chair Luria provided to VA.
All right, I'm gonna leave it with this, is that this Immigrant, Military Members, and Veterans Initiative is a program that allows non-citizen veterans who were removed from the U.S. for reasons other than committing aggravated felonies to reapply for citizenship or return to the U.S. So there's 2 bills in here, H.R. 1182 and H.R. 1183, which we don't really need. It's redundant. We already have a program in place. Madam, I yield back.
Well, thank you, Ranking Member Nels. I see that Representative Moore has joined us virtually. I'll now recognize you for 5 minutes for questions.
Thank you, Madam Chair. Mr. Flees, what are the weaknesses and limitations of the Veterans Benefit Management System, and how are we addressing them?
My apologies, Congressman Moore. I was looking for the unmute button. I think the challenges go back into the modernization of our infrastructure, right? So as we are looking at claims automation, we are going as fast as we can, but we are limited by the legacy systems that continue to plague our systems. And so that would be the limitation that I would suggest.
Okay, so what are the long-term plan? I mean, if we're dealing with certain barriers in the legacy, what do you see as the long-term plans for us addressing these issues?
I think the long-term plan is to modernize our infrastructure, not only our systems, but our databases, all the services, the middleware, all the parts that make up our infrastructure. That has to be the long-term plan. And I believe there's a bill we'll talk about here that gets the Benefits Automation Act. And so that really becomes our long-term plan. As soon as we can strip away those legacy systems, improve our databases, then we can really implement not only just claims automation, but much more robust features in our processes or our systems that support us, and not only make our employees better, but quite frankly, deliver more accurate, better quality, and faster delivery of benefits for our veterans.
Okay, and so Ms. Ogilvie, I'll kind of segue into this. The automation of certain claims could help the VA provide more timely and accurate results for veterans and mitigate future backlogs before they occur. But explain how you think the automation may help the process. I kind of understand we're trying to upgrade and get the systems to more modern. What are your thoughts on that?
Thank you for that question. There are certain areas where automation will complement the decision-making process. So there are certain areas where, we can have automated delivery of benefits where certain steps can be taken that don't require a person to touch that claim in that area. But the actual decision making for most of those is done by a person. I would also like to defer to Mr. Tellez to see if he has anything else to add.
Thank you, Brian. Congressman Moore, I would highlight and footstop what Brian just talked about. By using automation, we can take those steps that don't need a human to take an action and do all those steps, and we get right in front of the decision maker. Really, their focus is on the decision they need to make for a veteran. And that gets back to the claims automation pilot that Ranking Member Neal spoke about and others, where we're preventing those Boise rating veteran service representatives a document that helps them make that decision quicker. And I'm sorry.
Go ahead. No, please, Raymond, go ahead.
I was going to say, when we talk about Benefits of Automation Act, one thing that we could do is not only hand the rater a document that helps them make a decision quicker, but automate that decision by taking the data from that form, plugging it into VBMSR, so the rater looks at their screen, looks at the information, and either accepts the data, right, that supports a decision, clicks a button, and then it automates the process. That would be the ideal state. That we are not there yet.
Gotcha. Well, thank you. And with that, Madam Chair, I'll yield back.
Thank you, Mr. Moore. I understand Mr. Elsie is joining us virtually, that he may have questions, but I don't currently see him on the screen. So Ms. Miller-Meeks has joined us in the hearing room. I'll call on her next for 5 minutes.
Thank you, Madam Chair and Ranking Member. Ms. Ogilvie, given the current age of the veteran population, and I'll just say I'm one of those, veterans and probably in the more aged category, and the necessity for the VA to adopt electronic notification, would the VA support removing the opt-in provision in HR 6131 down the line?
Thank you for that question. Actually, VA is requesting that the opt-in provision is removed from the proposed bill. We simply recommend broader language so that VA has the flexibility to determine the requisite guidance for providing electronic notifications long-term without the need for additional statutory amendments. Although we are requesting that that language be removed, VA fully intends to allow veterans the opportunity to opt in to receive notifications electronically. But as technology develops and electronic forms of communication become the norm, then that is when maybe the opt-in language may be outdated.
So if I'm understanding correctly, remove the opt-in language now, but allow veterans to have the choice. And
Exactly.
then as we have further progressed through our digital age, then making it mandatory that they communicate electronically.
I would not go so far as to say make it mandatory. I think many years down the line, we'll probably have to reassess to see what's best for veterans and survivors. I do think that there's some people who may prefer paper notifications indefinitely, depending on age, and maybe indigent veterans may prefer paper notifications. So that would be an assessment that we would make several years down the line. But we're just requesting the opt-in language be removed from the statute so that, or the proposed bill, so that we can, we don't have to come back and request a statutory amendment.
Yeah, so it would be an affirmative request on the part of the veteran, and you wouldn't have to change statutory language.
Exactly.
Okay. And how do you think that e-notification, do you think that it could help prevent issues like delays experienced by veterans when GPOs printing subcontractor fell behind? Do you think this will help facilitate avoiding delays?
Yes, ma'am. It would definitely facilitate avoiding delays. The intent with electronic notification is to allow a veteran and a representative to receive the notification within minutes after the notification or after the decision is completed.
Well, I'm going to applaud those efforts and take to heart your comments. As a director of public health in Iowa in 2011, we actually started that process of notifying individuals by text and found that it improved our our visits and our no-show rate. So I'm going to applaud you on those efforts, and we'll look forward to addressing this issue in the opt-in provisions. Thank you so much. I yield back my time.
Well, thank you, Ms. Miller-Meeks. And as I understand, there are no remaining members who wish to ask questions, unless Mr. Nels, do you have any further questions? Well, thank you. So with no further questions for our VA colleagues, we want to thank you for your testimony today, Ms. Ogilvie and Mr. Tellez. We'll immediately turn to our third panel, so you can start taking your seats at the table here. And our VA witnesses are encouraged and welcome to remain on the Zoom so they can also hear from our next panelists, which are representing several of our VSOs. And while they are getting seated, I'll go ahead and recognize them. We're pleased to have representatives from 3 VSOs today. Your insights on these pieces of legislation are invaluable to the legislative process. And we also thank your ongoing work to support our nation's veterans and our nation. Your proof that service continues after military service. Our witnesses are Mr. Mario Marquez, Director of National Security at the American Legion. We are also joined by Ms. Tammy Bartlett, Deputy Director, National Legislative Service from the Veterans of Foreign Wars. And Ms. Candace Wheeler is joining us, Director of Policy from the Tragedy Assistance Program for Survivors, TAPS. Just remind our witnesses to pause briefly before speaking, but you're all here in person, so that should not really be an issue. And your written statements will be entered in full in the hearing record without objection. And so if everyone is ready, Mr. Marquez, we would like to begin with you. You're recognized for 5 minutes to provide remarks on the pending bills that we're considering today.
Thank you. Chair Luria, Ranking Member Nels, and distinguished members of this subcommittee. On behalf of the National Commander, Paul E. Dillard, representing almost 2 million dues-paying members living in every state and American territory, it is my duty and honor to present the American Legion's position on pending legislation being discussed here today. I will focus the time I have on emphasizing why Chairman Takano's bills are so important. I'd like to begin by stating that I am a retired Marine Sergeant Major and combat veteran with over 31 years of service. My family and I emigrated from Mexico in 1974, and I was raised to appreciate the opportunities this nation could provide us in the form of the American dream. As a result, I felt that as the eldest son, it was my duty to take the oath to protect and defend the Constitution of the United States of America against all enemies, foreign and domestic. While my military career is filled with fond memories, I would be remiss if I did not address the difficulties we experienced during the various stages of the naturalization process, a journey that almost cost me promotions, career-enhancing assignments, and the same livelihood that I fought to defend on behalf of other Americans. My first assignment took me to Okinawa, Japan, where deployments were consistent and I was focused on learning my military profession. Discussions about citizenship revolved around the difficulties in applying from an overseas location, so I was advised by many to wait until I returned to the U.S. At the end of that tour, I married my Japanese fiancée, and she was granted a humanitarian parole to accompany me. After filing for citizenship in California, faced with an intense deployment schedule and a 2-hour drive to the nearest immigration office, I was subjected to canceled or missed appointments, lost paperwork. The struggle to obtain my citizenship lasted almost 3 years. Once I became a naturalized citizen, we immediately filed my wife's application for permanent residency, but due to similar issues I had experienced, her process took 4.5 years. Just prior to my combat deployment in Iraq, while I was aboard ship, I received frantic news from my wife that she had unknowingly missed an appointment and she was going to be deported. I immediately contacted my congressman in California, Ed Royce, and then his successor, Ms. Linda Sanchez, who was able to assist my wife obtain her permanent residence. I then headed off to combat shortly thereafter, but I was at peace knowing my wife would be taken care of. During the same 8-year period that it took my wife and I to obtain citizenship and a green card, my military career exposed me to significant events, including 3 promotions, 2 reenlistments, 4 geographical moves and address changes, 6 different unit assignments, and deployments to real-world operations in Central America, Europe, and the Middle East. My story is but one example of the thousands of stories that service members, veterans, and their families go through in their journey toward achieving the American dream, to becoming a citizen, and for some, returning to America after being deported. Over the past century, military service has opened a reliable pathway to U.S. citizenship for more than 760,000 immigrants. In the last few years, however, the pathway has been obstructed. Citizenship assistance programs have faded from military bases. U.S. veterans from other nations are serving honorably and discharging as resident alien non-citizens. They come out confused. Why did their service not bring them citizenship, let alone expedited citizenship they believed was promised to them? And then in the worst cases, they are deported and disconnected from the VA benefits that they earned. Thank you, Chairman Takano, for your leadership on behalf of our immigrant military peers who served honorably but were later deported because U.S. citizenship was next to impossible for them while they were in service, fighting on our behalf. The American Legion proudly supports the Veteran Deportation Prevention and Reform Act, and the Honoring the Oath Act that addresses naturalization during service and protects our non-citizen veterans and their families from unwarranted deportation. We thank Chair Luria and Ranking Member Nels for their incredible leadership and for always keeping veterans at the core of their mission. It is my privilege to represent the American Legion before this committee. I look forward to answering any questions you have on these or any other bills in the written testimony. Thank you.
Well, thank you, Mr. Marquez, and especially thank you for sharing your personal story. I think that really puts in context how important this legislation is, that we consider it, and understanding, someone who served honorably like you, that you and your wife went through such hurdles to achieve your citizenship, and we want to make sure that we ease that process for current and future military service members and veterans.
Thank you, ma'am.
So next, I will recognize Ms. Tammy Bartlett with the Veterans of Foreign Wars for 5 minutes.
Chair Luria, Ranking Member Nels, and members of the subcommittee, on behalf of the men and women of the Veterans of Foreign Wars of the United States and its auxiliary, thank you for the opportunity to provide our remarks on legislation pending before the subcommittee. The VFW's views on all 14 bills can be found in my written testimony, and I will take this opportunity to highlight a few. The VFW supports H.R. 6165, which would require VBA to update an ongoing national training program for claims processors who process claims for PTSD, including instruction on stressor development and verification. Critical parts of this legislation are the requirements for an annual analysis and annual update for the procedural guidance. The VFW has long echoed OIG's concerns about VBA's overdevelopment of PTSD claims, to include PTSD claims related to MST. OIG reports that VBA consistently overdevelops for stressor statements, re-traumatizing MST survivors, combat veterans, and others who suffer from PTSD. VBA's own regulation dictates that evidence of an event in service or nexus to carry diagnosis would compel VA to confer the benefits. Contrary to regulation, VA's own processing manuals imply that veterans must submit stressor statements, even if the stressor is already recorded or easily discernible in the veteran's medical records. We look forward to this legislation shedding light on this problematic business processes, ensuring that VBA can do more consistent delivery of benefits to those who suffer from these invisible injuries. The VFW supports the intent of H.R. 6131, but recommends that the word may be changed to shall in Section 2, Part C, to require that VA implements this initiative. We believe without the authority change, and if we don't mandate the requirement, the intent of the bill falls apart. The VFW also recommends including the Secretary would be required to solicit pre-decisional recommendations from VA-accredited service organizations. This distinction would be key to ensure VA incorporates these recommendations. The VFW also supports the decision draft to change and amend Title 38 to update certain terminology related to marriage under the law administered by the Secretary of Veteran Affairs. This legislation would remove the language that defines a service spouse as a person of the opposite sex who was a spouse of the veteran. This change would be more fair and more inclusive and recognize the legality of the same-sex marriages. The legislation would also remove language that disqualifies a spouse from benefits if they lived with another person or, as quoted, held himself or herself out openly in public to the spouse of such person. Removal of this language would recognize the current realities of cohabitation that do not include receipt of a legal marriage benefit. It should also be noted that there are examples of similar terminology and definitions throughout Title 38 of the U.S. Code that merit consideration for updates. The VFW agrees with the definition and defining of the sense of Congress as outlined in the VA Principles of Benefits Automation Act. However, we are concerned with moving forward with the further efforts to define and codify the automation just yet. VBA is currently testing this automation. Establishing automation timelines and qualifying metric standards through regulation will likely be needed at some point, but waiting to review VA's pilot assessment first is crucial. Doing so will allow the committee to continue and conduct strong oversight of the automation process and work closely with VBA and VSOs to develop the framework that will accurately reflect the capabilities of VBA to deliver timely, accurate benefits. Finally, we support the pieces of legislation on today's docket that improve outreach and build the bridge to cover the gaps of knowledge and awareness. This is a forward movement VA needs to continue improving the lives of veterans and their families. Chair Luria, Ranking Member Nels, this concludes my remark, and I'm prepared to answer any questions you may have.
Well, thank you, Ms. Bartlett, for your remarks and feedback on the legislation that we're considering today. And finally, I'd like to recognize Ms. Candace Wheeler with the Tragedy Assistance Program for Survivors, TAPS, for your testimony for 5 minutes.
Chair Luria, Ranking Member Nels, and distinguished committee members. On behalf of the Tragedy Assistance Program for Survivors, thank you for the opportunity to represent the families of America's fallen heroes and to share our legislative views. A top priority for TAPS and our surviving families is the ability to retain benefits upon remarriage at any age. Current law significantly penalizes surviving spouses if they choose to remarry before age 55. Although we appreciate the intent of the DIC Modernization Act, we cannot support the draft bill as currently written. Requiring survivors to wait 10 years to retain 50% of their DIC benefits or 20 years to retain them in full places an additional undue burden on surviving spouses who have already lost their loved ones as a result of military service. The average age of a military widow in the post-9/11 era is 25. And like military spouses, they are one of the most unemployed and underemployed populations in the U.S. Due to the challenges of military life, surviving spouses often place their careers on hold and rely heavily on compensation benefits, health care, and education assistance. For surviving spouses like Elizabeth Davis, who lost her husband, First Lieutenant Matthew Davis, when she was 27 and a young mom, the proposed language would only move up the timeline 8 years for Elizabeth to remarry and retain full DIC, and would not allow her to keep SBP, health care, and education benefits. Elizabeth would like to remarry, but like so many other surviving spouses, she struggles with losing critical income and benefits for her family. Choosing to move forward with her life does not change the fact that Elizabeth will always be a survivor, nor does it change our sacred obligation to Matthew and to all veterans who earned their benefits through their service and sacrifice and secured them for their families. Another priority for TAPS, fellow survivor advocates, and the Modern Military Association of America is removing archaic language from Title 38 that may cause surviving spouses to lose their benefits and exclude same-sex couples from the definition of marriage. We thank Representative Newman for introducing the Supporting All Veterans Families Act, which updates the definition of surviving spouse to be inclusive of same-sex marriages and removes the hold themselves out to be married clause. Many surviving spouses choose not to remarry to protect their survivor benefits. Instead, some choose to live together with their significant others without marrying, but live in fear of being turned into the VA for appearing to be married. This clause also defines a surviving spouse as a person of the opposite sex, counter to the Supreme Court decision that legalized same-sex marriages. TAPS appreciates the VA's efforts to provide and strengthen services for the LGBTQIA+ veterans and their families, recognizing this population often faces stigma and discrimination, affecting their health, mental health, and overall well-being. TAPS is also grateful to Chair Luria for introducing the Honoring Our Promise Act. TAPS has long believed that collecting data on veterans, their families, caregivers, and survivors is important to understanding who we serve and how to improve services and benefits to these populations. We also appreciate that the bill focuses on strengthening access to VA information regarding benefits and services to survivors and conducts an assessment of resources of the VA's Office of Survivor Assistance. TAPS strongly supports H.R. 6165, the Department of Veterans Affairs Post-Traumatic Stress Disorder Processing Claims Improvement Act of 2021, introduced by Representative Negus. Many surviving families who have lost their loved ones to suicide have shared with TAPS that a significant contributing factor of their service member's death was PTSD, and that the claims process was often daunting and stressful for veterans to navigate. TAPS believes that standardizing the training program across all regional offices will improve the PTSD claims process for veterans and provide their families, caregivers, and survivors much-needed compensation benefits. We thank Chair Luria and Ranking Member Nels for introducing H.R. 6131, authorizing the VA to send electronic notices to claimants. TAPS strongly supports this bill, which will improve communication between VA and surviving families. Lastly, TAPS supports the Survivor Solid Start Act, introduced by Representative Mervan, to improve VA's outreach to surviving families. On behalf of our nation's surviving military families, thank you, and I look forward to your questions.
Well, thank you, Ms. Wheeler, and thank you to all of our witnesses for your testimony and providing feedback on the bills that we're considering today. We will now shift to questions for the final phase of the hearing and our last panel of witnesses. I will reserve until the end and ask my questions last, but I'll recognize Mr. Nels for 5 minutes.
Well, thank you, Chair Luria. Ms. Bartlett, thank you for your service. I see you're a lifetime member of the VFW. I am Post 3903 in Rosenberg, Texas, believe it or not. VFW, one of my most beloved organizations, it truly is. Question is, why does the VA or VFW support H.R. 6064, which would authorize a National Academy's review of disability exams for conditions related to MST?
Thank you for that question, Representative Nels. The National Academy would provide an independent review of those claim processes for those MST-related claims. It would give us an insight to some of the issues in the process. So getting that outside looking in view will help not just only process the claims faster, but also make them sure that it's clear that VA is going through with better processes and the training they may need forward.
Thank you. Mr. Marquez, you want to add anything? You'd like to comment?
Yes, sir. Thank you. National Academy for Science, Engineering, and Medicine is a premier organization that we trust and frequently rely on for evidence and research that we use in our testimonies. They're involved and have been involved in several VA initiatives and assessments, and specifically presumptive disability process as one of them. And we believe that their experience and outside point of view, while being experts in the field, will provide the MST process a good view that can provide unaffected, impacted internal points of view that can then be implemented for the credentialing and training that is required. Thank you.
I agree. Mr. Marquez, why does the American Legion believe that the VA should require contractors to submit DBQs in a machine-readable format?
Any process that can facilitate expediting the disability claim process for a veteran that can make their time from submission to receipt of benefits can only benefit the claimant, and we're in full support of that process.
Very well.
Thank you.
I'll finish with Ms. Wheeler. How would e-notification of decisions under H.R. 6131, which I'm the Republican lead with Chair Luria, improve the benefits process for survivors?
Thank you for that question, Ranking Member Nels. Yes, what we hear from surviving spouses and their children that oftentimes have a delay when they have letters come to them. One of the things that we hear the most about is every year spouses have to let the VBA know whether they've remarried or not. And oftentimes they will be sent a letter, but it's not actually every year. They don't send that out every year. So they're not even necessarily expecting it to come. If they were to let them know that if they hadn't changed their status, that could be sent to them electronically, they could reply electronically, this would really make the process so much quicker. We hear the same thing for students when they are moving from being under 18 and moving into adulthood. If they're still going to school, they have to do some claims as well for schools. They have to do advance notification. Oftentimes the process is slowed down. So we believe that not only being able to communicate to the survivor and the surviving family, but for them to be able to reply back will shorten the timeline. And we appreciate it. Thank you.
Yes, thank you, and thank you all for what you do for our nation's veterans. And I yield back.
Well, thank you, and thank you, Ms. Wheeler, for that feedback on the bill that Mr. Nels and I are working on together. I think we agree that there's a much speedier way and more efficient way to approach a lot of these processes, so we hope to be able to implement that. I see that a couple of our colleagues are joining us virtually. I will now turn to Dr. Ruiz for 5 minutes for questions.
Thank you very much, and as the chairman of the Congressional Hispanic Caucus, the issue of deported veterans is important to me and CHC members. It is appalling that such an issue even exists. No veteran should be treated as a second-class veteran. All veterans should be treated the same. That means if you served our country and you are eligible, you should remain in this country. You should receive your care, your benefits, and other help or due process here in this country. They risked their lives for our country, fought for our country. They deserve and earn to stay in our country. The CHC strongly believes that those who have served our country, regardless of immigration status, should not be deported, and their cases should be adjudicated within the United States, just like citizen veterans. To address this issue, the CHC has called on administrations for years to stop deporting our service members and veterans. We have also called on the Department of Veteran Affairs to ensure deported veterans have access to quality medical care. Additionally, several CHC members, including CHC Deputy Chair Nanette Barragan, Natural Resources Committee Chairman Raul Grijalva, Representative Vicente Gonzalez, CHC Vice Chair of Policy Darren Soto, Representative Salud Carbajal, Representative Juan Vargas, and Senator Alex Padilla have each introduced legislation that fall within the scope of the Judiciary Committee to address this issue. While we strongly commend and support the steps that the Biden administration has taken to fix some of the problems, including establishing the Immigrant Military Members and Veterans Initiative, which will coordinate efforts with DHS, DOJ, and the VA to better serve our non-citizen service members, veterans, and their families. There is more work to be done. Today, I'm here to express my full support for Chairman Takano's two bills, the Veterans Deportation Prevention and Reform Act and the Honoring the Oath Act. The Veterans Deportation Prevention and Reform Act is a comprehensive bill that would address several barriers that non-citizen service members and veterans face. It would prevent non-citizen veterans from being deported, improve tracking of non-citizen veterans, and repatriate eligible deported veterans back home. The Honoring the Oath Act would establish a Military Family Immigration Advisory Committee that would advise DHS and DOJ on whether a non-citizen member of the armed forces, veteran, or family member facing removal proceedings should be granted citizenship. Most importantly, these bills would provide a better pathway to citizenship for eligible applicants. It is imperative that we immediately rectify this system for our service members and veterans. As CAC Chair, I strongly support these bills and look forward to working with the VA Committee Chairman and Judiciary Committee Chairman Nadler to also advance CAC members' bills through the legislative process and to provide the relief and protections for deportation that our veterans deserve. And I encourage my colleagues on this committee to support these bills as well. Director Marquez, you received your citizenship through your military service. Can you please explain your process?
Thank you, Dr. Reese, for that question. I appreciate the opportunity. So as I said in my opening comments, I chose not to apply while overseas because all the advice I received was negative, and the experience from an overseas post as a young Marine, I simply could not afford to fly to Guam or Hawaii on my own dime after taking time off from a period in my life where, frankly, I was learning how to be a Marine still. And so it was pushed.
Do you believe that the process has gotten better or worse for military members over the years? And do you see a discrepancy between junior enlisted members and those in leadership?
Yes, I do. First, I believe that the process has gotten better when in the form of some of the access online and ability for us to file our forms, but it has not gotten any better when we talk about the policies that have changed continuously with regards to eligibility of certain types of service members for different types of programs. And so it has become more difficult because of the policy change and fluctuations, and there's no consistency. So while someone senior has the ability and life experience to potentially tackle those issues and seek advice and maybe afford an immigration lawyer, no, younger service members are distraught, they're torn apart, they're in fear, and they're embarrassed to ask for help because it's a personal issue. You want to become a citizen, but you're fighting so hard to be a good service member, but you're afraid that they're going to label you in the military as a problem child because you need all this time to go work on your personal issues. So it's
That's
developed.
very important that we overcome those barriers. You mentioned that when you were deployed in Iraq, that your wife was facing deportation proceedings back home. What effect did that have on you while you were deployed?
Thank you, Doctor. It was significant. I couldn't stop thinking about what's going to happen to my wife, even though my wife is from Japan and she has a family structure, and my family is from California. The thought of me going into combat and my wife is back home alone on the East Coast, managing all her finances as a Japanese then citizen, barely speaks English, trying to get by on her own, it was devastating to me. I was worried about my Marines. I was worried about could I execute the duties I had to do. And thankfully, I engaged 2 members of Congress, as I mentioned earlier, and that's the only way that it was rectified. It would not have gotten rectified had I not taken that action. They would have deported my wife, and my command or anyone else would not have been able to do anything about it as I was headed to combat.
You know, and your wife served our nation too, because the service that our service members give is a family service to our country. So thank you very much, and thank you to your family and your wife for serving our nation.
Thank you, Doctor.
Well, thank you, Dr. Ruiz, for your questions and your support and work on these issues. I next will recognize Representative Moore, who's joining us virtually for 5 minutes for questions.
Thank you, Madam Chair. Ms. Marquez, why does the TAL believe that automation efforts at the VA should be guided by a set of core principles, such as requiring a person to make the final decision and ensuring that due process rights are protected?
Thank you. The automation process, while it facilitates streamlining just everything that benefits what I spoke about earlier with regards to veterans receiving and ensuring they have access to their benefits, it's important that we continue to improve the process while allowing employees, a human being, to actually make the analysis, final recommendations, and decisions that are so critical that a computer cannot offer. I think it's vital to keep that into the process of decision-making, and the American Legion stands behind that 100%.
Thank you. What additional principles do you think the American Legion would like to see added to the sense of Congress?
So I thank you for that question. I've thought about this, and while this may sound like a cliche item and something that is overused consistently, in looking at the principles that exist now, I believe that we have to reemphasize, place an emphasis on protecting the privacy and safety protocols of the claimants and their information as we share and use that information potentially across various organizations and entities. And I think that needs to be added to that so that we can reemphasize and keep it at the forefront as we do business. Thank you.
Thank you. Any of the other witnesses, would y'all like to respond as well?
Thank you, Representative Moore. This is Tammy Bartlett from the VFW. As far as the provisions of automation, the VFW is supportive of the sense of Congress, but again, we urge that we just take some time and wait for the assessment to come back from the pilot program. We don't want to put guardrails and qualitative measures in place and then maybe have to come back and re-rectify that.
And thank you for that question. I would also add that we are very much in support of modernization. We believe it will help our families greatly. And we do share some of the concerns of the other organizations, but we would like to see, we don't think that should stop it moving forward. And we need to have a good framework going forward, but it will greatly help our veterans, their families, and our caregivers and survivors to be able to access their benefits. So thank you.
Yes, ma'am. Thank y'all. And this question actually be for the whole panel, so we'll continue with the theme of just getting everyone to respond. But please explain why your organization supports automating temporary total disability ratings for hospitalized veterans. And it doesn't matter which order you go in, but let me hear your thoughts, please.
Thank you for that question, Representative Moore. So we've seen with veterans who are hospitalized at the time with their service-connected disability, they're unable to provide for their family while they were sitting in that hospital trying to get better. So by allowing this temporary rating system will allow that family to continue on until that veteran can come home.
The only thing I'd like to add to that is that we believe that having a manual backup so that there is no further delay in the case we run into complications or certain types of evidence that are maybe not machine readable or something to that effect, that having the manual ability to quickly carry out that temporary disability claim is critical to this process. Thank you.
Thank you.
Yes, and I would add as well that it adds an extra stress to the family and to the veteran while they're going through this process. And so being able to actually have that rating take place, at least for the interim period of time, will allow that family a peace of mind, and we greatly appreciate it.
Thank you. Thank you to the panelists for that. With that, Madam Chair, I'll yield back.
Well, thank you, Mr. Moore. I wanted to close out this portion of the panel by saying thank you again to Mr. Marquez, Ms. Bartlett, and Ms. Wheeler for participating in today's legislative hearing. Your testimony and comments have been, very insightful and I think informative for us as we move forward in shaping this legislation. And in interest of time, I'll submit the questions that I had for the record and know that we have a continuous dialogue so that we can continue to discuss these topics. Before I close the hearing, I would like to make a few remarks, but would first like to offer Mr. Nels the opportunity if he has any closing remarks.
I have nothing. Thank you.
Okay. Thank you, Representative Nels. And again, it's a honor, pleasure, both as veterans to work together with you on especially this legislation to help speed up that delivery of information on claims to our veterans. It seems like, the 21st century. I know Ms. Miller-Meeks joined us earlier, and she said in the state of Iowa, in her capacity there in public health, they had done this 10 years ago. So, I think we can help the VA sort of catch up to what other organizations are doing as well. I'd like to thank the witness for the testimonies they gave today, as well as the time they spent preparing for the hearing and the work that you do day in and day out on these important issues. We will take the feedback from this hearing to ensure that we produce legislation that we know is effective, but also empathetic and holds up our responsibility to care for those who served our nation and their families, because we've spent a lot of time today as well talking about survivors and how we can better serve them. For those who stepped up and served our country and have been deported, we want to ensure that we're doing what we can to help them and also smooth and ease that process for those who are willing to serve our country and want to make this country their country and gain citizenship, that we work to make that process easier and smoother. And we are working with the VBA to help bring their systems in line with current technologies, especially with those for backlogs of claims, and especially with focus on veterans who have suffered from PTSD. So we've covered a lot of topics in today's hearing, and we hope to take the information from this hearing moving forward to improve the legislation that's been presented today, and help provide better benefits, better care, and better service to our veterans. So with that said, and without objection, that includes today's hearings. All members will have 5 legislative days to revise and extend their remarks and include extraneous material. And the hearing is now adjourned. Thank you.